in a defensive shooting. Now, I know in my soul that it's right. So I know these are always fact dependent, right? Always super fact dependent. But let's say that in my mind, I know that this was me using a firearm to defend my life in a way that was responsible. But does a district attorney always see it that way?
Well, understand first off, we're normally not arguing about the law.
Right.
When you say, I know in my mind it was justified, it may very well have been based on what actually happened. But what actually happened isn't always the case, right? I mean, we lawyers don't always agree on what the facts are. In fact, we never agree on what the facts are. Let me tell you how this goes, right? You get into the shooting that you know in your heart is good. Let's imagine you survive the arrest and all of that, and we wind up meeting. You say, Mark, I need to talk to you about this situation. And you tell me what happened. And even though you were charged, you tell me what happened. And I say, you know what, John, this sounds like a great shooting. This is really a good shooting. No problems here. And then I sit down with the prosecutor. And I say, look, man, let me tell you what's going on here.
Right.
This happened, this happened, this happened, this happened. And that's when my guy pulled the trigger. Prosecutor's going to say, those aren't the facts I got.
Yeah, that's not what really happened. We're arguing about the facts, not the law.
That's not what victim's friends, bystander. Now, remember, there's two different varieties here. One variety is just people don't always get it right. Even not that they're trying to lie, right? I mean, even your typical car accident, what color was the light? You can have different witnesses. Some say green, some say yellow, some may say red.
Right.
People don't, especially when you're dealing with a high-stress situation. So we're almost always fighting about the facts. Think about the reverse of this. If we weren't fighting about the facts, if we agreed on the facts, it'd be a pretty easy case to resolve.
Yeah, I mean, those are usually pretty quick, right?
I mean, if the prosecutor and I sit down and we agree on every fact, very rare that we would say, geez, I don't know if this is justified conduct. I mean, there are cases, right? There are many gray area cases. But most of them aren't like that. I can just tell you, 25 years of doing this, the issue isn't just what happened, it's what is everybody going to say happened?
And we know, because we talk about this with foresight stuff all the time, that human memory is an interesting beast. And what we say can and will be used against us in a court of law.
There's lots of data now about identifications of eyewitnesses. They really can't be trusted very well. Even confessions. Some people confess, even though they're false confessions. They may have been pressured. They may think, well, it's the right way to go. They won't believe me if I tell them the truth. Or who knows what, right?
All right, so let's just say now we're in an instance where, all right, so I wasn't smart. I didn't do anything in advance to prepare myself for the legal aspect of the fight after the fight, all right? I get in a gunfight. The responding officers say, nope, we're going to hook you up, and so they arrest me.
There's a lot here you're not going to like, right?
Well, I want to know, though, so this is why. All right, so I get arrested. They take my gun, they put it in evidence, whatever, so my gun's bye-bye for whatever foreseeable future. And I flip through the phone book, flip, and I see Attorneys for Freedom. And I go, I'm going to call the Attorneys for Freedom. For those of you kids, I get on the Googles. Will they let you have your smartphone to look somebody up?
Absolutely not.
No, you're not going to get your phone.
You're in custody. They may throw yellow pages at you or something. But remember, that's your first battle, right? The first thing you care about is getting out of custody.
Right.
And you're going to think, hey, I lived here my whole life. I'm not a flight risk. I'm not a danger to anybody. The judge is probably going to see it differently, right? Because guess who's informing the judge on what the facts are? That cop who arrested you, who doesn't believe your story already. So when you say you're not a danger to the community, what a judge who may have to be reelected or reappointed, depending on the jurisdiction, is thinking, do I really want to put this person back out in the community who may have just unlawfully used a handgun or a rifle or something in a way that's a huge problem? Right? The last thing you want as a judge is to release somebody, have a new problem, and then have cameras in your faces saying, hey, judge, light on crime.
Right.
Why did you release this person? So that the easy thing to do as a judge is to put a high bond. And it's really popular now in Maricopa County, where we do a lot of cases, to put a cash-only bond to make it extra hard.
You can't even use a bail agent, really, at that point.
You got to put up cash or a cashier's check. There's no more of this 10% down and then a bond from a bondsman with some collateral to secure it. You got to put the whole check down. Makes it extra hard to get it. That's really fight number one, getting out of the jail.
So I should hopefully get a phone call right? I mean, that's not constitutionally required, but it's kind of known courtesy, right?
You're right. Usually you get on the phone. But what normally happens in these situations is we don't find out about it from the person who's arrested. We find out about it from that person's wife, girlfriend, mom. We get a call, usually frantic, so-and-so was just arrested. And, okay, well, where are they? We don't know. Which department arrested them? We don't know.
Right.
So we got to go on a hunt and try to find out where they are in the system. But here in Arizona, they got to put you in front of a judge within 24 hours. Okay. Most places, they're going to put you in front of a judge because there's a real danger, right, in arresting somebody, not putting them in front of a judicial officer, and then sort of working on them for a confession.
Right.
So we've sort of balanced that with due process principles by saying, let's get them in front of a judge pretty quick. Most places are going to be 24, 48 hours, that kind of a thing. So you'll see a judge pretty quickly. What we normally do is we'll hustle down to the jail and meet people. Because remember, on the phone, you can't tell anybody anything on the phone. That phone call is recorded.
Right.
And they do listen, and they will play it in your case later on. So you absolutely can't say anything on the phone.
So there's a first principle number one. When your spouse or whatever, your loved one calls the attorney, now hopefully you've worked that out in advance, right? So that you know this is coming already. But we're going to say this person is the least prepared in the world. And so you got to get your spouse, my spouse has been arrested. This is where they are. I need help.
Kind of like a fire drill, right?
Right.
If the house is on fire, what are we doing? If somebody gets arrested, what's the plan? You should think about that. Who do we call? What are we going to do for bond money if we got to get somebody out? I mean, these things happen. People who don't do anything wrong. I was one of them. I got arrested. I got charged. My entire experience is on my website. If people want to see, and go to Attorneys for Freedom.
We will put a link in the description. So
put a link in there so they will see. I'm one of the very few criminal defense attorneys who has experienced this entire situation from the client side.
Oh, wow.
So yeah, it gives me an interesting perspective on what happens. But when you're sitting there rotting away in a jail cell and you don't know if your life is ruined or not, it puts the kind of stress on you that you really don't want to be making difficult decisions right then. That's why get this stuff worked out in advance. So, all right, so you either get out of jail or you don't.
Well, okay, well, no, we're not done there. I got some more here. I want to talk more about this. This is important stuff. So when the spouse calls and says, hey, I got somebody who's in there, I mean, at that point, you're not just going to go traipsing down to the jail on goodwill.
You're right. You got to make an arrangement with the lawyer. No lawyer is going to get up, especially in the middle of the night, and hustle down to the jail, because it's not just a matter of hustle down the jail, right? It's going to take a while to get down the jail. Then they got to find your person. Then they're going to say, oh, they're in intake and they can't visit right now. And it could be a very long, could be a half a day type of an experience. So you'll have to work out some kind of an arrangement for that lawyer to get down to the jail.
What's typical, Mark? I mean, are we talking about? I'm thinking the financial piece. I mean, the lawyer's gonna want money for this.
Sure. Well, there are many different arrangements. Okay, we have many cases at our firm that we consider pre-charge. So these are people who have thought in advance. Some detectives calling me, asking me questions. They've come in and retained us, and we're ready to go. We're paid. We've got motions ready to go, motions to set release conditions. We got bondsmen lined up. We got letters sent to the prosecutor. We're in pristine shape. If you're going to be charged with a crime, that's the best case scenario. Second best scenario is maybe, in our case, I can only speak for us, they're a member of the Attorneys on Retainer program.
Sure.
So they've already got us on board. We got something worked out. All that's pre-planned and set and ready to go. Third scenario is you're someone off the street.
Yep.
So then it's going to be a question of which jail are we, right? Because there are some jails that are many hours away. There are some jails that are close. So we are likely going to talk to that person and arrange something to go down to the jail to meet them. It's possible that, depending on the case, sometimes I listen to the facts and I think this guy's going to get released pretty quick. Where I may say, okay, let's not go to the jail right now. He's going to be released today. Let's wait, and then he can come into the office. So it'll really, you start diverging depending on the facts at that point. But assuming we have to go to the jail and there's going to be a big argument, we will come up with some kind of a rate to do that. It could be anywhere from, you're probably talking $500 on the low end to, and of course it depends how far the jail is away, but maybe $1,500 on the high end. And I have personally been at those jail hearings at every hour of the night. They run them around the clock.
Yeah. They have a graveyard shift judge there.
They do. I've been there at 2 a.m., 3 a.m., 4 a.m., 5 a.m. We call them at our firm the late night freedom fight. And so all of my attorneys have done these many times. And so we gear up for the late night freedom fight and we go down there and make the pitch, because if you don't do that, although you have an opportunity to try to change the release conditions, it takes time.
Right.
Because the first thing...
And that's days you're spending in jail.
First thing that the prosecutor will say, if you don't like the decision of the judge, we can file a motion. They'll say, we got 10 days to respond. So now you're rotting there for 10 days. That's even if you can get a hearing at the end of the 10-day period. A lot of times you can't. We've got a pretty good team. We call around. We'll get that hearing scheduled on the 10th day. But who wants to sit in jail for 10 days and rot away?
Right.
So it can be, I tell people, really, criminal cases come in 3 phases. Phase 1, where are you going to be when we're fighting the other phases, in or out?
You want to be out.
Of course you want to be out.
So let's say, okay, they're going to get you in front of a judge pretty quick, and you got some reasonable bond conditions that you could handle, whatever, so you get out of jail that night.
Keep in mind, too, the argument is almost always going to be 2 main points. Number 1, are you a flight risk? Do we have reason to think that you're going to come back and stand trial, or do we have reason to think that you're leaving? Things that are in that category are like, where do you live? Are you visiting here from China?
Right.
Or do you live in another state? Or do you have strong ties to this community, right? Do you have a job here?
Right.
Are your kids in school here, homeowner here? Those kinds of things makes it more likely you're going to stay here. The second inquiry is normally the danger to the community type aspect. Now, this frankly doesn't square with presumed innocent, right? Because lots of times I'll stand there in front of the judge and say, excuse me, judge, you're saying, hey, he committed this horrible crime and he's a danger to the community, but he is presumed innocent, right? So for you to presume that he committed this crime and say he's a danger to the community sort of flies in the face of the presumption of innocence. So there are definitely some constitutional frictions there, is how I would put it. But we try to make that case as forcefully as possible. Other things that go into that calculation: do you have a history of being a danger to the community? You have prior felony
you got priors.
convictions. Is this your first time? And what's alleged? Is what's alleged, does it sound like it could be a self-defense situation, or were you caught on the way to do some horrible demonstration of evil or something? So, and then, of course, what did you say? Did you say, as soon as I get out, I'm going to start shooting and killing people? That's the kind of thing a judge will consider,
Of course.
So these are the kinds of facts that lawyers will put together and make a pitch to the judge to try to get more favorable release conditions. And remember, it's not just the bond. There can be lots of other release conditions: where you get to live, whether you get to go back home, who you can contact and can't contact. Sometimes there are ankle bracelets that you have to wear. Many places have what we call pretrial services, which is sort of like being on probation before, like, we're going to release you, but you're going to report to somebody and they're going to kind of keep an eye on you while you're released. There's home arrest. There's many different types of options available. So I think people sort of give that short shrift sometimes, but I can tell you, if you're in, the thing you care about at that point is getting out.
So I think, to me, just this little bit right here, the first thing that comes to my mind is you want to have all this stuff planned out in advance.
Well, of course, if you know what life is going to bring around the corner, then you plan for it. Most people will have some brush with the criminal justice system at some point. May just be a speeding ticket or something like that. But
I've never had a speeding ticket.
But in my case, and you can see if you watch the video, I had some lying cops. In my case, there were Border Patrol agents, Customs and Border Patrol, and I had some thugs, some real thugs. And so even if you did nothing wrong, you could still be accused of doing things wrong.
These things happen.
You might do something small and somebody takes an attitude against you, right? They don't like something about the way you look, or they misunderstood something about the way you said something. And so they're going to, cops have a lot of discretion, whether they're going to release you or book you into jail, those kinds of things.
Yeah.
What they're going to put on these forms that go to the judge, discretion all through the justice system. I think it's always a good rule for life. Don't be a jerk. Right?
Of course, right?
Always a good rule for life.
So I think we've talked about this before, that, when the responding officers show up, you want to invoke your rights. Don't waive your rights, but don't be a jerk, right? Hey, listen, I need to talk to counsel. And
I always tell people in a very nice way, don't say, F you, I don't talk to cops, or things like that. What you say in a nice way: hey, I've got a friend, he's a lawyer, he told me never to say anything to the police. If I could call him, if he says it's okay to talk to you, I'd be happy to do that. no qualified criminal defense lawyer
Right.
is ever going to say, okay, go ahead, talk to the cops. But it's a very nice way, a friendly way, a respectful way. Look, and I tell people, you do not have to respect police officers. That's your business, whether you do or you don't. However, you should at least pretend to respect police officers when you're dealing with them.
When you're dealing with them and you are on the pointy end of the stick, you want to be respectful. Even if you don't have personal respect for cops, you want to be respectful at that point because they're the ones who are going to determine how hard this is going to be for you in the initial phase.
Yeah, and just lingering on that point for 1 second, it's just so broad, and this is one of my newer pet peeves here, this idea of talking about how I feel about, say, cops. This is such an overgeneralization, right? I mean, to make a statement, I like cops or I don't like cops, is, to me, an ignorant type of a statement to make, right? It's like saying, I like males or I like females or I like people who live in Chandler or something. I mean,
Right.
there's a huge spectrum of varieties of police officers, right? There are some on the edge of the bell curve who we say, wow, salt of the earth.
Right.
Really
Incredible
looking for
people, yeah.
Excellent. And then there are thugs on the other side
Sure.
who are wearing badges. And it's a point you've made on many occasions.
Yeah,
and
yeah,
I make
they
all the
exist.
time. Our position here at our firm is we are very, very pro good police officer and very, very anti-bad police officer.
I think any good thinking person is that same way, personally.
Of course, stepping back from that and realizing you don't know who you're dealing with at the moment.
Right.
You
Yeah,
should-
you get the luck of the draw, which one of those is going to show up.
Yeah, so take a step back, be respectful. You don't know if you're dealing with some crazy thug who could pull out their gun and say you made some furtive movement and try to shoot you or something in some of the videos that we've seen of police officers
have.
out of control, or someone who put the handcuffs on extra tight or something. You don't know who you're dealing with. So the best advice is be respectful, be professional, and shut the heck up.
Right. Yeah, we've heard that here many times. Okay, so gosh, man, we've just got this thing. Now we might have to have, come up with somewhere $500 to $1,500 to talk to for the attorney to come down and walk us through the process. We might have to have 10% of a bond available to us pretty quick to get us out, or even maybe even bigger than that, a cash bond. You could have show up pretty quick. Where do we find $50,000 today?
This is why the videos that you do and the advice that you give about just move on from some of these problems.
Oh,
if
boy.
You can. Don't, if you can get out of there. Of course, in Arizona, there's no duty to retreat. We all know that. That's a legal matter. But as just a brains matter.
As a practical matter.
Practical matter. If you can get the heck out of there and avoid the problem in the first place, I mean, I can't stress enough how important that is for people who carry guns.
Nice. All right, next time we're going to talk about the next step from there, talking to the district attorney and charges getting filed and going on from there. Guys, we have just gotten started and we've already spent like 50 grand or more. So I look forward to talking to you again next week.